Hey, everybody, and welcome to Thursday night. Hey, John Skiba here from the Consumer Warrior YouTube channel. Welcome to Thursday night here once again on the channel where we talk about all things debt related, whether it's debt collection lawsuits, bankruptcy, wage garnishment, credit reports, FDCPA violations, all that kind of stuff. That's what I do each and every day, not only on the YouTube channel, but here in my law practice in the state of Arizona. I am a licensed attorney in the state of Arizona. I'm not licensed anywhere else. So you should not take anything that I talk about here on this live stream as legal advice. It's just some guy talking on YouTube, so take it for what it's worth. If you need specific legal advice and you're in the state of Arizona, my information is scrolling here along the bottom of the screen. You can reach out to me. I do free consultations. If you're outside the state of Arizona, I'd recommend you contacting an attorney in your specific state. So, okay, so there's already a number of questions already over in the comments section, and that's how we do it. If you want to have a topic that you want to talk about and you're on YouTube, YouTube is the only place where you can put your comments. But put your question in the comment section. I'll put it up here on the screen, and we can go over it. And I'll do my best, as one radio guy used to say, to give marginal legal advice. So. All right, let's jump in with the questions. There's a couple good ones right off the top here. Tony said, I received a 1099-C for a debt about 4 years old and hasn't been settled yet. G is marked in box 6. Does this mean that the debt is forgiven? The balance due still shows on my credit report. How do I proceed? So this is a really good question. The 1099-C, what that is, that's a form that a creditor they'll issue you if they have essentially written off the debt or forgiven the debt, or like in your case, they're saying that it's uncollectible. So box 6 on the 1099-C form, G and the code, I looked it up, G specifically is that there has been a decision or policy to discontinue collection. So what they've done, the fact that they have forgiven the debt, or that they have really what they're doing is they're deeming it uncollectible. They're not forgiving the debt. And when they do that, they're saying, hey, we're counting this as a loss on our books. And so not only is that a loss that they can treat as like a write-off on their taxes, they can send you the 1099-C, and then you have to include that as the amount that's been written off as income when you file your taxes. So it's something where often if you get the 1099-C, that means that they're not trying to collect on it. They're not going to sell it to a junk debt buyer, but not always. I have seen situations where they have continued to try to collect on it even after the 1099-C. And then if they get money from you, they have to amend their 1099-C or withdraw it altogether. So at this point, I would say, particularly if you're using an accountant, often you can get by or around the tax implications of a 1099-C because if you're technically insolvent, if your debts outweigh the assets that you currently have, there may not be any liability there on that 1099. So good question, Tony. I would check that out. Brandon says, just got served yesterday from Midland Credit Management for a bad credit card debt. The next step is to answer. In my answer, can I also include a settlement request to either a discounted lump sum amount or a low monthly payment? My recommendation is that you do not do that. Here's why. There's a time for settlement discussions. You could reach out even before you file your answer to the attorney and do the settlement discussions. But really, the answer, all it is the court wants to know, is there a dispute? We have the complaint over here, your answer here. They want to know, is there some dispute between the parties? So you go line by line, stating whether you admit or deny the allegations that they have in their complaint. It's not a time to tell your side of the story. It's not a time to submit settlement offers or let them know that you can't pay the full amount. And actually, that could cause you some problems down the road, because if you're essentially admitting the debt by offering a settlement offer, they could file for what's called judgment on the pleadings, and you could end up losing the case just right out of the get-go. So my recommendation is, if you want to try to settle it, is to reach out to the creditor directly or to their attorney, offer the settlement. In most jurisdictions, settlement discussions are not admissible in court. It's Rule 408 of the Rules of Evidence. And it would limit them. They wouldn't be able to come into the court and say, hey, Judge Brandon agreed to pay this debt. They can't do that. The worst they can say is no, and then you file your answer and you continue to litigate the case. So I would not do that. One thing that's important to understand is that the court does not take an active role in trying to settle the dispute. The judge is like an umpire. They're calling balls and strikes kind of thing. They're there to say you're going to win or you're going to lose. They're not there to determine if you can pay it or if you're in the financial position to pay it. That's not the role that the court takes. So I would recommend not doing that right there. All right, let's see here. Alex, each and every week, thank you for supporting the channel. Can you file bankruptcy to buy time to settle debts and then dismiss your petition later? Shout out from Yuma, Arizona. Is it cold in Yuma? I woke up this morning to snow in the mountains surrounding the Phoenix Valley. I have lived here since 2003. And while we definitely will sometimes see them at the very top, this was snow like all the way down to the benches, which you do not see in Phoenix. You don't see snow here. So it's kind of a crazy winter. To answer your question, typically, no. I wouldn't take the approach that you're saying there. So if filing bankruptcy will stop all collections, but if you file a Chapter 7 bankruptcy, which is what most people file, it actually, you can't voluntarily get out of that. A lot of people don't realize that. You file Chapter 7, you're in. And so there's very limited opportunities to get out at all. Really, there isn't. Chapter 13s can be voluntarily dismissed. But typically, I mean, if you're going to file bankruptcy, you don't want to kind of mess around with the system like that. You just file it, get rid of the debts that way. If you're going to settle, take that approach. But I wouldn't recommend a bankruptcy filing just for purposes of settling. I think it's going to end up causing more problems than it solves there. All right, let's see here. Let's see what Mark has to say. Mesa Justice Court, I motioned for compel arbitration. Mid-first attorney's motion for 30-day stay for me to initiate. I did initiate with AAA and just received my letter from AAA. The business is also directed to submit its current consumer arbitration clause for inclusion. And the business will also incur a $600 registry fee, $250 expedited review fee, and filing fees. And you are seeing, and then we're going to go, and this is why seeking private arbitration often works, because they require a deposit. So $31.25 that they're going to have to pay to arbitrate. There it is, Mark, your $2,000 debt. They're not going to do it. They'll seek to dismiss. So you took a step that, we're seeing more judges who are saying, that's fine, you will compel arbitration, but go ahead and initiate it. The fact that you initiated it and you took that step, now, here's the only other step that I recommend is you file a notice, like with the Mesa Justice Court there, notice that you've initiated private arbitration. Maybe attach a copy of the initial initiation documents so the court can see you did that. And then just so the court's aware that you're in compliance with what they told you to do. So that's what I would recommend. You did a good job there. I think that's the way to go. So, all right, let's see what CJ has to say. I went to court today with hopes I would get to cross-examine their witness. Wrote down all your questions, only to find out that requirement was there a template with the attached statement. I'm not sure. Maybe clarify that for me, CJ, as far as what's happening there. The court was requiring you to have some type of template. If you want to clarify that, I can follow up with that with you a little bit further. So, all right, let's see here. Okay, Tony, I think this is the same question. I think I talked about the 4-year-old debt. How do you get it removed? Okay, so now if the debt, the 1099 just means that they are counting it as a loss. It doesn't mean that it's going to fall off your credit report. It's going to stay on there for the whole 7 years as far as it being derogatory. You could try to file a dispute with the credit bureau if you believe that it shouldn't be there based upon that 1099, but it's unlikely that they'll probably keep it there in my experience. All right, let's see this one here. If a business has a lot of customer deposits for products that are still outstanding, does it make sense for an LLC to file Chapter 7, or should the business just go dark? This is a good question. Actually, I did a consultation on a similar type thing today in my practice here in Arizona. Typically, companies, limited liability companies, LLCs, corporations, they typically do not file Chapter 7 bankruptcy. The reason is a company is not entitled to a Chapter 7 discharge. The only reason why individuals file Chapter 7 bankruptcy is because they get a discharge order from their judge that says they're no longer legally obligated to pay those debts. Companies, formal companies, not sole proprietorships, but LLCs, corporations, they're not entitled to a discharge. And so really, there's not a huge reason for an LLC to file a bankruptcy. Usually it's the owners of the company or the members because there's likely personal guarantees or they're personally liable on it. I can tell you in my 20 years, I think I filed 2 Chapter 7s for companies. And the reason where it starts to make sense, one of them, I remember they had a business and they sold lawn furniture, like for poolside and stuff like that. And they had a giant warehouse of inventory. The business was going under. They didn't have any employees left. Everything was shut down. There was no money to do anything. And they needed to get rid of all these lawn chairs. We're not talking just a few lawn chairs. We're talking like a whole warehouse of them. And so by filing a Chapter 7 bankruptcy, the bankruptcy court then appoints a Chapter 7 trustee to the case. And that Chapter 7 trustee's job was to go in and to liquidate all those assets, pay off any creditors, and then they just close the case down. So in most cases, like you were saying, does the business just go dark? Yeah, I had a law professor say once, there's 2 ways that businesses can die. They can die and you can have a very simple funeral for them and just close the thing down, or you can have a real fancy funeral. It's a big party, which is the Chapter 7 bankruptcy process. He says in most cases, just let it die. So don't go through that whole process of, you can just do a normal winding down, sell any assets, pay off the creditors, and close the doors. The issue that you have is when you're running into when there's a lot of assets, the personal guarantees. Those are the kind of things that actually push people into a personal Chapter 7. Would be the personal liability that you would have there. So. All right. Hey, appreciate those are all really great questions. Those are questions that we don't get very often, and I think all of them are relevant. I get them quite a bit in my law practice, so I think that it's great to have them here. So, if you have specific questions, particularly about like the arbitration, debt collection lawsuits, you can check out. I have put in the link there, a link to my tutorials. I have the Consumer Warrior University, which we've got this now super low. I've never sold these things for this low, and you get full access to my entire library. I think there's almost 20 different courses. They all include templates, video instruction, all that kind of stuff. Plus, you're part of the Consumer Warrior community where we talk about these things in more depth. So check out the link in the comments section there and see if that's something you might be interested in. All right, let's talk about this one. Will LBNB actually fight for a $5,000 lawsuit? Lots of lawyers say that it will not take it to trial. In my experience, it's backwards. It's different than what you would think. And I've talked to creditors' attorneys about this because, you say if someone had a credit card and they owed, $60,000 on it, and then a credit card where there was like $1,000, you would think, of course, they're going to sue you on the $60,000 one, not the $1,000 one. A lot of times, it's the exact opposite. The reason why, and this is the education I learned early on from the creditors' attorneys, is look, most people, if you get sued for a $60,000 credit card, they're probably going to file bankruptcy. They're going to get rid of the debt and get rid of it that way. And that's not to say that they won't file it. They could. They're going to look at your background, your ability to pay. But they know a lot of people, when they get hit with a really big lawsuit, they'll probably file bankruptcy. Almost no one files bankruptcy over $1,000 lawsuits. And they know they can file those things in just giant volume. They can probably settle them out either for $500 to $800. Or what often happens is they end up with a default judgment, and then they take the default judgment. They get attorney's fees on top of it. They get interest on top of it, and then they churn that thing forever. And that $1,000 lawsuit turns into 8 or 9, and then they keep garnishing on it. So I actually do see the opposite to be true, that they actually pursue the small ones a little more aggressively than the big ones. So, all right. Brandon had a follow-up regarding the answer to the lawsuit. Do I still need to file an answer if I contact the attorney and agree on a settlement? So what I would do is look at the summons that you got when you were served with the complaint and the summons, and look to see if there is, what's your time frame is to respond. Like in Arizona, you have 20 days, 20 calendar days to file a written answer. If you get the settlement taken care of before your answer is due, make sure you get something in writing from the other side acknowledging that you've settled it and this is resolved. That's the only time I would not file an answer, because if it's still kind of just negotiated or you've just talked about it on the phone, you don't file an answer, they could end up with a default. So I would make sure you get something in writing, even if it's an email, a letter, whatever it is, that's binding, to be able to get it taken care of that way. All right, let's see here. OG Guy 1234 says, can you put student loans in a 100% Chapter 13 plan to save on interest? So student loans in a Chapter 13 bankruptcy are considered, they're almost always considered a general, non-priority, unsecured debt. And so what they usually do is they receive a pro rata distribution after all the priority debts are paid, like taxes, child support, those types of things, secured debts. If you're in a 100% Chapter 13 plan, that means that you're going to pay 100% of all allowed claims in your Chapter 13 case. And so the short answer is, yeah, if you have the ability to pay off all of your debts at 100%, 100 cents on the dollar in your Chapter 13 case, you can do the student loans can be included in that. There's no issues with that. So, all right. Follow up with Log Home says the LBMB 5000 suit is against someone that is judgment proof. The creditors do have quite a bit of information on you, and they decide to file the lawsuit. They're going to have to believe that the person is judgment proof. I've also seen, particularly if the defendant is relatively young, like in Arizona, civil judgments are good for 10 years and they can be renewed every 10 years for the rest of your life. So if they're fairly young, sometimes they'll say, hey, we'll file the lawsuit and get the judgment, and we'll just let this thing churn interest for the next 10, 20 years. And then maybe by then your situation will change. That's a problem. So, all right, let's see what Dan says. The question is about discovery. The limits on standard discovery are determined by the amount of damages claimed. Base of the claim filed by the plaintiff, my alleged debt is within tier 1, $50,000 or less. This is an Arizona question, by the way. The different tiers are Arizona. They're actually fairly recent changes in the rules. If requesting for production of documents and admission, there's a table that shows tier 1 is limited to 5. What does that mean? Could it mean 5 items per request? No, it means 5 requests total. So, but it doesn't, if you're asking for, so you have your request for production and it says you're limited to 5. Those 5 different requests. You could request, one request could be that you would like the bank statements covering the, from January 1st, 2022 through December 31st, 2022. That could be request number 1. So it's not that you're asking for 5 individual documents, but that there's a 5 and within reason. It's one of these things, if you get too far out the scope of it, you'll probably elicit an objection from the other side. But you have 5 requests, and you can they can be categories of documents like that. So I think it's one of these things where throw it out there. If they object, they object, and if you need to resolve it through the courts, you can that way as well. So, all right. Let's see here. Should customers who have deposits for products that are still outstanding with an LLC be listed as creditors on a personal Chapter 7 for the owner member to avoid potential litigation? My opinion on that is yes. If you own a business and you're filing personal bankruptcy and the business is closing down, even if the contract or the agreement was with the business itself and not you personally, I would still list it. I would list any potential for liability that you might have on a personal side, just so that there's no specific issues there. That's it's permissible on a Chapter 7 bankruptcy, Schedule F it's called. These are just general unsecured debts. You can put it on there. There's even a little check the box if it's disputed or unliquidated. You absolutely can list those, and that's the best practice to be able to protect that. So, Brandon, thank you for the super sticker here and for supporting the channel tonight. All right, I think we'll do that. That'll be it for tonight. We'll wrap that up, but I appreciate everybody checking in. Go check out the Consumer Warrior University. We've got more and more people signing up all the time for that. I think we have a great group in there, a lot of good discussion, and you get full access to all of my courses, all my templates, tutorials, everything that I've ever made or produced. You get full access to it immediately. So go check that out. It's in the comments section. We'll catch you next week.